first panel is IP licensing roundtable, new challenges and opportunities, including living in the artificial intelligence generative AI world, which is really a game changer for all IP, especially copyright, but really all IP and all learning. So please come up, panel. And I'm going to hand you over to Myron Kassaraba, who's going to moderate.
Great, thanks, Bruce. So CRI is very happy to be hosting this great event. I think this is my third IPAS, and I always appreciate the opportunity to sort of let you step away from the day-to-day, hear from some really terrific speakers, and really discuss some meaningful issues. And I would be remiss if I didn't shout out to PJ and Liz from our marketing team who helped put this together. So thank you, PJ and Liz. So as Bruce said, our topic is IP licensing, new challenges and opportunities living in an AI world. So super interesting and very timely topic. We're fortunate today to have panelists with us that represent IBM, one of the world's most prolific generators of IP, and a company that's had great success in licensing their intellectual property, as well as an AI pioneer. MGB Innovation, which is the licensing and commercialization arm of Mass General Brigham Hospital, I think previously known as Partners Innovation. They generally consistently generate over $100 million in licensing revenue from innovations that come out of Mass General Hospital. And the Copyright Alliance, which represents the copyright interests of over 2 million individual creators and over 15,000 organizations in the United States. So I'm the Director of Commercialization here at Northeastern Center for Research Innovation. We're responsible for licensing technologies and IP developed at our colleges and labs, from our faculty and researchers to industry and to spin-outs. And I also manage the AI computing and software portfolio. So I'm going to try to more act as a guide of the conversation, but expect this to be a really interactive session. And so we'll welcome questions from the audience afterwards. And I think we'll start by just doing a brief sort of introduction of your organization and your role in licensing and AI.
Sure. Is this on? I'm Nimra. I am a Senior Director of Business Development and Licensing with the Mass General Brigham Innovation Office. As Myron mentioned, we are the business development and tech transfer arm for the Mass General Brigham system. The two premier hospitals, the research hospitals, include Mass General Hospital and Brigham and Women's Hospital. My role is on the licensing team. I oversee the departments of radiology, surgery, cardiology, and a host of others. So between radiology and surgery, there's a lot of AI innovations happening within the systems. We're responsible for protecting the IP, for licensing to industry, and also for coordinating any kind of preclinical collaborations with industry to develop new technologies.
All right, I'm Keith Kuberschmidt, the CEO of the Copyright Alliance. As was mentioned, we represent the copyright interests of over 2 million individual creators, you know, the photographers and the performers and the authors and the artists and the songwriters and software coders and everyone else out there that has a creative bone in their body and is trying to make a living or a career as a creator. We also represent the copyright interests of over 15,000 different organizations that rely on copyright. And we do no licensing at all, but our members do, and they hope to, especially with regard to AI, and I know we'll get into this in more detail later on, but that is honestly one of the biggest problems that we face, is that a lot of my members' works are being ingested by AI developers and being used by AI developers, and they're not being licensed. And my members are, and those who are even not my members, who are creators, are not being compensated and not being asked for their approval either, and that's something that's got to change, and I know we'll talk about that in more detail a little bit later.
So I'm Bill LaFontaine, General Manager of Intellectual Property at IBM. My partner in crime was Manny Schechter, who was up here earlier. So he's the good guy. He thinks about patent strategy and how to create it, and I'm the bad guy who tries to get people to pay for a license when they use our IP. I'm also responsible for the research business development. We have one of the last corporate research labs left in the world. And one of the ways that we're able to do that is by finding partners out in industry and other places to work with us at the intersection of a business unit research and them to find ways to accelerate innovation for both IBM and these other business units and the like. And then my team a couple of years ago did the IBM MIT AI Center. So a collaboration, 10-year collaboration that we're now more than halfway through to try to advance AI, fundamental AI technology with researchers from both sides working together collaboratively, trying to find ways to impact society and industry as a whole.
Great, thanks everyone. So before we jump into the meaty topic of generative AI, I did want to kind of check in on sort of the general state of licensing. So estimates of the global patent licensing market are somewhere between 175 and 240 billion. That's from 2019. According to a report by Allied Market Research, the global copyright licensing market is valued at about 11 billion. And the Association of University Technology Managers, of which we're a part of, reported that in fiscal year 21 that member universities and nonprofit institutions reported their revenue of about $3 billion in licensing income. Just to give you another sense, Qualcomm in 2020 reported its patent licensing revenue of about $5 billion, which accounted for about 27% of their revenue. And though we measure licensing by the income and the revenue, it's really about the products and services, companies, books, performances, music that IP enables. So, you know, $85 trillion worth of GDP. I don't know what percentage of that is driven by IP, but it really is. You have to take a look at the impact that the intellectual property that all of us are generating has. So, Bill, you've been involved in commercialization of and leading the efforts at IBM. You know, what's changed recently in sort of the landscape of licensing, and what are some of the biggest factors you think are affecting the prospects for the future?
So first, why do we license IP? A, it's for income, and B, it's also for freedom of action. Probably, if you ask the CEO of IBM, he'd say freedom of action first, money second. And that's when the baseline, that's where we've been for decades. It's in the last decade or so, given a series of court decisions, I think someone else used the word efficient infringement. I'm looking at my colleague back in one of the tables. And that's what we face. Earlier days, we would be able to go see a client, show them some intellectual property that they were using, and come to some agreement on a licensing fee that they would pay, and a cross-license between both sides. We could go compete in the marketplace and innovate with an extra level of freedom that we knew we would be able to build a product and get covered. In the semiconductor space, pretty straightforward. Most people there are very, you know, they well recognize that innovations that are coming out of the labs to go do that next generation are A, patentable, B, extremely valuable, and C, I'll take a license. With the advent of e-commerce and more digital platforms, we run into a series of individuals at companies who know nothing about IP at all. They know nothing about patents, and their view is, I get to use whatever I want to use whenever I want to use it. And then the second step is, well, if you think I'm infringing, sue me. So we've walked ourselves over time where if we don't enforce our patents in the marketplace, in legal jurisdictions, we get people basically giving us the finger. I know it's not quite the right word for this audience, but it's the truth. They say, you know, go to hell, go directly to hell, and if you don't want to go to hell, sue me. And so we've now had to, over time, you know, file a series of lawsuits. And then we've now walked into many of the discussions we heard earlier today, which is now you have a new gauntlet to go through. and that is your patent valid? Is it enforceable? And can you get a jury to agree with you those are the cases? If you can get past all the other challenges and then get a fair royalty paid to you for the innovation you've done. So it's, what I've seen over the years is this requirement to go, and if you litigate a few people, then you can get others to pay attention because they don't want to be the next one on the wheel. But if you get a setback, and it happens, obviously, we've had a few of those, all of a sudden it becomes people then that say, well, I don't need to worry about these guys. They lost here, they lost there. So back to the efficient infringement piece. So it's a constant battle.
Great, thanks, Bill. So Nimra, you're more on the side of taking innovations that are coming out of MGB and though you may enforce, as Bill or the folks at IBM, what are you seeing in the general types of things that you're licensing? Is it shifting away from patents? Is it more to software, to know-how? How do you even look at trade secrets and sort of the mix of the things that that maybe you were licensing 5 years ago versus what you're licensing now?
Right. I'd say 5 years ago, really, on our bread and butter in tech transfer has always been licensing patents. And that's really evolved over the last 5 years, especially with AI coming into healthcare so strongly. And I would say we are focusing more on copyrights and know-how. And the conversation is shifting from pure licensing of IP to actual co-development with our industry partners, where we come together before there's even an invention, because there's so much clinical insight and so much know-how and so much to learn about how to implement that product that the company is envisioning, that the parties really need to come together before to actually create the invention. More and more, we're bringing together the expertise of the clinicians, the research at the hospitals, and just the general know-how of how clinical workflows happen with the engineering and technology expertise of industry. So we're shifting the conversation from just pure licensing to sort of co-development and co-implementation.
Great, and Bill, you had talked previously when we were discussing that there's a shift there at IBM as well, where you're looking to do more co-development rather than sort of pure patent licensing?
Absolutely. I think if we were looking at where the income stream is coming from, a lot more is partnerships, whether it's in various industries where we'll bring know-how and they'll bring know-how. We'll jointly work together to create something that they may take to market, we may take to market, or do that collectively together. Basically, we're doing it just for acceleration. We see that you can get a lot faster working with other parties. They bring a different perspective. The economics make sense, and we do more and more of it these days.
Great. So staying kind of on the patenting and licensing topic, but bringing in AI, certainly we've found that trying to patent AI algorithms has been challenging, both with patentability issues, the fact that algorithms change at such a rapid pace that it's difficult to take a snapshot that you would represent in patent claims and have them still be relevant a month or years later. That's not stopped companies from filing AI patents. Others argue that the value is in the software and know-how and how to use those algorithms and guard their algorithms as trade secrets. So both for Bill and Nimra, I mean, are you seeing, what are you seeing relative to your organizations? Are you filing AI patents and sort of what's been the impact of that to your organizations?
From the academic medical center perspective, we're not filing as much on the AI algorithms per se. We are often filing around the system that's built around the AI algorithm, where the algorithms may be a black box, but the patent and the claim is more around the inputs that go into the algorithm and the outputs that come out of it and how that impacts clinical care or treatment of patients, et cetera, et cetera. So we're not filing a ton on AI, but whenever we are, it's more of the system around the AI than the AI itself, which is generally where the expertise of the clinicians lies within our system. We're not really an engineering powerhouse like MIT.
And would you be more apt to do those filings if there's sort of a path to either to a spin out or where you've got commercialization potential?
Yes, absolutely. That's across the board. For anything that we file on, it's truly commercialization potential, regardless of how patentable it is. If it's not commercializable, it's not really our position to file on it.
Right, so you're not really trying to build out your portfolio, or even though I know that universities keep rank of how many patents and those types of things are issued. How about you, Bill, on the AI patenting side?
I should ask Manny the question. No, the answer is yes. We're continuing to file patents in the AI space, but we're also far more conscious about what ought to be a trade secret. The other thing we're learning in the early days of AI is, by the time a patent got granted, the whole field had moved past some of the things that we had invented. So we're being more purposeful about that piece. And the other major focus on the AI patenting is discoverability. If you're going to file a patent you can't discover somebody else is using, maybe a trade secret's a better way to go look at that problem. So continue to file, trying to be very, very mindful about that discoverability question, and recognizing this field is just moving at such a tremendous pace that it's not like some other technologies where first to get there is the only solution. Now we're finding that it pivots multiple different directions.
Great, thanks. So Keith, we haven't forgotten about you, and thank you for making the trip up from DC today to join us. So let's shift to sort of the topic of the moment. Generative AI tools like ChatGPT, Bard, DALL-E, Stable Diffusion, and the list goes on. Copyright and fair use is not a new issue. I worked in the imaging and publishing worlds early in my career and remember discussions in the late 80s with PageMaker and image scanners and Photoshop and digital cameras about copyright and digital rights management. And it seemed like people were like a little bit concerned, but that sort of went away. Obviously now, there's, I think the stats are 1.8 billion digital images are uploaded every day and shared on the internet. There's been, prior to sort of generative AI, there have been AI tools that help you identify a plant or an animal, or if you're a coin collector, those types of things. But it seems like the rules have changed a little bit with generative AI. So I mean, you represent both content creators and owners. I read, and actually if anybody's interested, there's an excellent blog post on your website kind of about some of these issues with fair use. Can you kind of walk us through how you and your members are viewing this?
Yeah, sure. I mean, before I do that, I want to take a step back and just say one thing, because what happens is whenever we speak about AI, we complain a lot about what's going on. And so I want to make clear at the outset that we, as an organization, the Copyright Alliance, and our members support responsible and ethical development and use of AI. Matter of fact, we have quite a few members who are using AI in their creative endeavors. And so I want to kind of make that clear at the outset. But it should come as no surprise with every opportunity that new technology provides. It also provides certain challenges, and AI has no doubt provided a lot of challenges. Our general approach at the Copyright Alliance to not only challenges in AI, but other technology or other type of challenges that we may come across is one of some certain guiding principles, right? To make sure at the end of the day there is respect for creators' rights, and make sure that the goals and the purposes of copyright are upheld. And so we approach AI with that type of approach. Unfortunately, I think the way things are going right now, I don't think those guiding principles are being met at all. There's several issues, and I know we'll talk about during the course while we're up here, we'll talk about a bunch of them. But the biggest issue, as I mentioned at the outset, is the ingestion of copyrighted works which are used as training materials without permission, i.e. without a license and without compensation. There's another issue as well, and I'll read an excerpt. Hold on one sec. I'll read an excerpt. This was an article from the Washington Post a couple of weeks ago, which did an analysis of chatbots that are using Google's C4 data set. And what it reveals is that the proprietary, personal, and often offensive websites that go into an AI ingestion of data. And then it went through and named a whole bunch of different websites that were scraped by the particular data set. And then the fact that over 2 million copyright symbols were included in these copyrighted works. So what that shows is that it's not just legitimate works that are being copied here, it's a lot of pirated works, right, that are being copied. And so there's a lot of problems with that as well. Licensing does exist. A lot of my members have AI-specific licenses. Matter of fact, they will tailor their content for those AI licenses to make them easier to use and identify by AI. But like I said, there's the issue of most of the ingestion that is going on isn't going on in a licensed way. And so it should come as no surprise, there's about 6 different lawsuits pending right now against AI developers. Let me see, there's 2 class action suits. There's 2 lawsuits that were brought by Getty, one in the UK and one here. Then there's a couple other lawsuits as well, and we're tracking all of those. The biggest defense, and it was mentioned here about fair use, the biggest defense seems to be, well, this is fair use, we don't need a license. And so what I know I have done and my team have done is gone back and looked at a lot of these fair use cases that they're saying this allows for use of copyrighted works without a license. And the biggest one seems to be the Google Books case, where Google created this book search where they copied all these books and then allowed them to be searchable. And that case is extremely different than what we have going on here. In the Google Books case, it was held to be fair use. It was a case brought by the Authors Guild against Google, and it was held to be fair use. But in that case, what Google was doing was copying the books, taking out the information in those books, and using it for informational purposes. What they weren't doing is copying all those books to create new books. And that's what we've got going on in AI right now. The other big difference is the authors and the publishers, back when the Authors Guild sued Google, there were no licenses. There were no licenses to allow Google to copy all these books. That's different than what's going on now. You talk to a CCC or Getty or a whole bunch of my other members, they all have specific AI licenses, and if it were to be held to be fair use, those markets would be absolutely destroyed, and that's a huge problem. The other thing I'll mention is some of the AI developers will say, well, we're not copying, or it's only RAM copying. Well, that's still copying, and if you're copying the information and the expression, you can't say, well, yeah, I know you're only using the information perhaps, but you're copying entire works. And when you copy entire works, that implicates copyright owners' reproduction right, and if it's not a fair use, it's going to be considered to be an infringement. And so we've heard from some others, matter of fact, I was on a panel the Copyright Office held a couple of weeks ago where they held this listening session, and someone said, well, it's an intermediate copy, and so that's allowed. And if you go back and look at the cases having to do with intermediate copies, Sega versus Accolade, Sony v. Connectix, those are very, very specific cases having to do with computer software and having to do with interoperability. Matter of fact, we went back and read the Sega case, and the Sega case, the judge says, if this case were to involve traditional literary works and not software, the outcome would be different. And that's what we've got going on here. So there's a battle brewing, there's no doubt. It's going to be handled presumably by the courts first. I know Congress will probably try to get involved, and we'll deal with that. But at the end of the day, we are just looking for 2 things. Those guiding principles I mentioned before, respect for creators' rights, and also upholding the value and the purpose and the goals of copyright law. And we don't think that's happening right now with regard to the ingestion of copyrighted works by AI companies.
Great, thanks, Keith. Nimra, has the shift to generative AI had an impact on kind of the types of research that you're seeing coming out of MGB? And are your clinicians worried about sort of the use of some of these tools in the hands of the public?
I don't think we've seen as much in terms of invention disclosures yet. I'm sure it's coming, but generative AI is starting to be looked at across the system, from chatbots on websites to like patient scheduling and call systems, et cetera. And you know, it's going to make its way into potential clinical decision making, and that's where there is a concern about are appropriate disclosures being made about the use of generative AI and things like that. It hasn't quite crept into the work that we're seeing, but across the hospitals, it's being looked at as to how it's going to impact healthcare as a whole.
Yeah, I'm sure you've got a lot of startups and companies knocking on your door wanting to, have you license or deploy their software. It must be an interesting challenge to figure out how to evaluate those and to see whether you're going to deploy them, with patients.
Right, and I think there's a lot of opportunities for us to, again, work collaboratively with those entities, see if we can validate any of the work that they're bringing. Do they bring value to the system or not? Can we test them clinically? But yeah, they also raise a lot of just general ethical questions about the involvement of AI within healthcare.
Yeah, I'll come back to that in a minute. But Bill, IBM was at the leading edge of commercializing AI with Watson and Watson Health. So what's different now? Was OpenAI's kind of public release of ChatGPT an inflection point? Is it just part of the continuum? What's the perspective from someone who was early in the commercialization of AI technology?
So when we first started out with Watson and the Jeopardy demonstration, our first direction was go build things like Watson Health, go build industry businesses with AI infused in them. And I think we got a little bit ahead of ourselves. These things always take much longer as you anticipated. So what we've done is the pivot has been to embedding AI into other people's technology. So an example, just fortuitously this morning, SAP just announced that they're embedding Watson into their entire platform. And so that's where we've pivoted from building AI-related businesses to embedding AI into other enterprise solutions that people are going to take to market. With ChatGPT, I think, again, personally, they were able to do some things out there that a large corporation could never do. They put it out there, people try it. If it gives you a flawed answer, or if you do something that doesn't work out for you, you don't really have much legal recourse, because what are you going to go? You're going to go after a company that has no real assets, no real money. So they had the opportunity to experiment out there in ways that a large corporation can't do just from a liability and risk perspective. We have a major effort in this space around large language models, building compute that this can sit on top of, but it will be hardened for enterprise use. The data sets will be those that enterprises want to go teach them, train them on. And so it's going to be an integral part of the company. If you listen to our CEO, he'd say we're a hybrid cloud, AI, and quantum company. AI embedded in solutions we let other companies embed into what they're going to take to market. But yeah, we see it as an important inflection out there, but it's not hardened for the kinds of, think about regulated markets like banking. You certainly could not use this in a banking environment without getting a tremendous amount of risk from government intervention. So when we work with these kinds of folks, we're going to try to help harden it in a way that can provide value to people without the other risks.
Yeah, and I think Russ from AST, we were talking last night, and he said that they've tried using ChatGPT for some prior art searching, and ChatGPT was really good at making up references that didn't exist. So don't know if we'd be relying on it for kind of mission critical applications. So now let's talk about training data. Keith, you brought this up. You know, I can tell you from my time at MIT and here at Northeastern, researchers have an insatiable appetite for data to train their AI models. Mass General Brigham, one of the world's premier healthcare institutions, several healthcare platform institutions are either leveraging their data. I think, as you mentioned, the Mayo Clinic's got their platform program where they're actually taking equity positions with startups that are utilizing their data. Dan Dardani, who's here from Duke, one of my former colleagues at MIT, has a data licensing program where they're incentivizing clinicians to curate, label, and package their data in more of sort of a standard licensing business. So, Nimra, you're in the radiology area, which is super hot. What's changed in how you approach partnering and commercialization using access to your data and clinicians?
Yeah, so over the last 5 years as a system, we've been establishing policies and guidelines about how we use our data in connection with giving access to third parties to use our data to train algorithms. And the goal has always been for us to be good stewards of the data, for us to use the data in a manner that is ethical and in line with our charitable and academic mission. That said, with the evolution in the space, with more and more AMCs kind of licensing their data, where before it was sort of a hard no that we did not license data at all, our policies have been updated where there is potential for that. But leadership is still looking into how we can do that in a way that aligns with our mission. We're not going to be just selling data outright. It has to really open up research opportunities and have the potential to really impact patient care. So those are being considered on a case-by-case basis. It's not sort of a free-for-all just yet.
Gotcha. And Keith, do you anticipate that there's going to continue to be confusion, about where data can and how it can be used? Is this an issue that needs to be settled by the courts, by Congress, by the U.S. Copyright Office? What's the path to some sort of resolution from this confusion?
Yeah, I think all of the above. I think in terms of the use of copyrighted work as training materials, I think the courts are going to get the first go at it, really, because like I said, there are several cases that are pending. The class action suits will take longer, so I have a feeling the suit by Getty, or maybe there's a couple other suits there's Thomson Reuters suit that's been going on for a while that could, but that's got a lot of other sort of extraneous facts to it. So I would think that the courts would be the first ones, but more and more these days you're hearing from members of Congress who are starting to want to draft legislation. Maybe it's not specifically on copyright issues, but I mean, because obviously, we're talking about a lot of issues here, and copyright issues are not the only issues, right? There's a lot of people who are concerned about these data sets and where are they coming from? What are the sources? And we talked about, inaccurate data, like coming up with fake prior art. People are concerned about that. And matter of fact, that's one of the reasons that a lot of these AI developers go to and use copyrighted works, because they're such high value. They know they can be relied on and things like that. And so that's why more and more we see those copyrighted works being used.
So what about, just to follow up on that, what about creative works generated by AI and qualifying for copyright protection? I think there's a recent ruling by the U.S. Copyright Office on the graphic novel Zarya of the Dawn, and apparently the author tried to register her copyright, was initially approved, was then rejected, and then the Copyright Office came back and gave a more limited sort of protection. I mean, I'm sure your members see both sides, right? Because you've got people who are wanting to utilize these tools in order to create content. I mean, where do you come out on AI as an author, and is it entitled to copyright protection?
So that's a real difficult question, because you've got a spectrum of creativity. On the one hand, you've got something created completely by AI, and there's a case pending in the courts right now, the Thaler case, that will decide that issue. Matter of fact, Thaler also had a patent case that was just denied cert last week, and there's a similar copyright case going through the court systems right now. On the other end of the spectrum, you have works created totally by humans, which has been what's been happening for many years, of course. And then you've got this spectrum in between where you've got, for instance, AI-assisted human creation. And then on this side, a little bit more, you've got human-assisted AI creation, right? And you've got this spectrum, and the big question is, where do you draw that line? Now, the Copyright Office came out, I think maybe about 6 weeks ago, maybe it's 2 months ago now, I came out with some guidance on the issue. I use that term a little loosely here because it's generated a lot of concern and questions. I think they did do a good first attempt at providing some guidance, but it's fairly rudimentary. It doesn't address a lot of issues. There are certain inconsistencies with their own rules. So I know us in the copyright community, we're watching certainly what's happening in the patent community because this seems to be a bigger issue right now. We've got a couple of people who are trying to force the issue in copyrights, but in patents, as we heard Bill talk a little bit about, it seems more prevalent trying to get some level of intellectual property protection for AI generated works. And so, honestly, we are still trying to figure a lot of this out, I think like a lot of folks are, in terms of where to draw that line. We've been getting a lot of demonstrations by individual creators that show us how they are using AI to help them with their creative process, and that will hopefully help with our thinking in order to figure out kind of where we think the line should be drawn. But I'm sorry, I don't have a hard and fast answer for you. I'm not sure I will, actually, even a year from now, but we'll see. We're certainly working on it and thinking about it, and it may be just one of these that sort of we come up with a standard and it needs to be applied on a case-by-case basis. One thing we don't want to happen, though, is the Copyright Office is very different than the Patent and Trademark Office, right? And the Patent and Trademark Office, as a former examiner, I can tell you, used to engages in a substantive examination and analysis of the claims and the invention. That doesn't happen at the Copyright Office. And in the Castanova case, there was a very long decision, and they delved into it and did a real lengthy examination and issued a lengthy opinion. We would hope that would not be the case. The Copyright Office does not have the resources or the abilities to do that. And so we're hoping the Copyright Office does not turn into a mini version of the Patent Office in terms of its examination process.
They'll just use AI, right?
Yeah.
So, Bill, opinion on AI as an inventor? The Davis cases in various jurisdictions generally came out and said no. I think Australia said yes, but I'm sure there's going to be more challenges. But any predictions on where things will end up?
Oh, I don't know how to predict that one at all. I think a human needs to do the invention. I think there's going to be a slippery slope with how much do you use tools and how do you represent it. But I don't want to touch that one with a 50-foot pole.
So speaking of tools, there are commercial tools that are becoming available. And do you see that changing how any one of us do our work, either in assessing? I know that we've got a tool now that with the push of a button can generate a tech brief for a technology that we're going to market. So it looks at the disclosure, looks at a bunch of other information, and then generates something automatically. Do you see in the way you do your jobs, the impact of those types of tools?
Oh, absolutely. Especially when somebody shows you 1,000 patent portfolio and you want to get some idea as to any relevance, any interest, we're beginning to use AI tools to help us window it down, knowing it's not going to give an exact answer by any stretch of the imagination, but it might get us in the right zip code. Because if we think about the cost, we'll see, 4,000 or 5,000 patents a year. Someone will show us and say, hey, we think you might have an interest in them. Notice the word interest parenthetically. And if we were going to ask lawyers to review each and every one of these, that would be, I mean, the sheer time and expense to do that would just be prohibitive. So we've built some capabilities where we could take that 5,000 and whittle it down to, maybe it's 50 a year, which, it doesn't seem terribly unreasonable that these 50, we ought to go have a real human being look at them, because maybe there's something that's interesting there to us that we should consider either acquiring or licensing. And that's our way to try to be far more efficient. So I think AI is going to be used for those kinds of efficiencies, recognizing it's not 100% accurate, but you can whittle out enough of it that you can do a second screen and get enough, are we going to miss something? The answer is yes. But if you risk that what you miss versus the thousands of hours you'd have had to spend to be perfect, the economics overwhelmingly suggest you ought to use AI to help filter things.
Great. Keith, Nimra, any comments on?
Yeah, similar. We've also sort of established a workforce within our office to try to look at how tools like ChatGPT can be utilized. I think generating tech briefs is a great example. And to echo what Bill said, we have a huge portfolio, over 1,000 patent applications filed every year, and we constantly get requests from industry looking to find patents in a general broad area, and it's very hard to filter through our system to try to find those, and kind of using AI tools to help at least have a starting point to have those conversations versus taking 6 months to dig through our portfolio to find the right stuff.
That's great. So I think I do want to leave some time for questions, but sort of last question would be, just a brief sort of crystal ball, paint a picture of where you think we'll be 5 years from now with AI licensing, or any sort of final comments to the audience on this topic.
I guess I'll jump in. 5 years from now, I don't know that I'll be up here, maybe AI or something. But no, seriously, given how quickly things are moving, if things continue to move at this pace, I mean, who knows honestly, where we might be. There's a lot of different policymakers that are saying, whoa, let's try to slow things down. There's a big battle, obviously, going on between tech companies to try to be the biggest and the bad, or the biggest and the best, right? And that's not going to stop until, maybe won't stop at all. So honestly, I have no idea. I'm hoping, we do have a lot of, I talked about ingestion and about how we have a lot of people who aren't playing by the rules, the copyright rules. We also have those like an IBM and an Adobe who are, and it's not fair to them when you've got someone who's abiding by the rules in copyright. And so honestly, I have no idea how this is going to shake out, but hopefully those companies that are abiding by the rules within the next months or years, that they will.
Great. Bill?
I think there's a whole host of activities that we all do on a day-to-day basis that AI will enable dramatically better than it does today, getting answers to questions. We're using one in-house around HR topics, like if you want to ask about certain pieces of information. And the success rate, in other words, answering the question that makes the person who asked it happy they got what they needed versus having to go to an individual, is improved dramatically over time. So it doesn't replace humans, but there's, and I can see it when I watch these tools being used, there are some very simple questions people ask that these chatbots and other things are getting better and better at answering and making people, people are feeling comfortable using them and leaving humans to do, the much more difficult, complex problems. So I think AI has a long ways to go, but I think you're going to see it whittle away at tasks that when you ask it, ChatGPT, when you ask it something that it should really understand around policies and procedures for a company, it's going to spit it out with very high confidence, and then it's going to improve productivity. And as our CEO has told others, people are going to have to get used to working with AI as an assistant as the enterprise moves forward.
Great. Nimra, future of healthcare, is it promising?
Yeah, I'm hopeful that in 5 years, AI has a very positive impact on healthcare. There's a huge need in healthcare with staff shortages and immense physician burnout from just the administrative burden that clinicians face. Historically, I'd say healthcare has been the slowest of all industries to adopt innovation, but COVID really seemed to change that. And with COVID and kind of the big shift towards telehealth, and we saw healthcare systems sort of evolving overnight to change how healthcare is delivered. So I'm hopeful that adoption of AI will be done in a way that's positive, that improves efficiencies, lowers cost, improves access to healthcare, and AI can really enable all of that.
Terrific. Well, and we could keep going, but I think we've got a few minutes for questions. So thank you all, and we'll.
Yeah, Keith. First of all, just thank you. It was a wonderful presentation. I've been spending a lot of time in the AI area trying to train individuals in the business community and attorneys in this area. I had a question for Keith. Specifically, when you look at the Zarya situation, right, and you look at the new images that were created through Midjourney, and I can completely appreciate the assessment that was done, which must have been very difficult, especially when you're dealing with someone who's so passionate about their own creation. My question for you is with regard to the prompts. There was a statement made with regard to the prompts saying that it really didn't come up to that level of creativity so as to make the individual the author. Instead, it really was the AI that was the author in that case. Do you believe, in your opinion, especially based on the level of detail that people are getting into in these prompts now, from specifying like the hex numbers for colors to what's going to be in what exact area, the placement of the palm tree, the color of the water, like all that detail, do you think a prompt can get to the point where a person actually does, in fact, become the creator / the author instead of the AI?
I think absolutely, and we saw, we brought in a visual artist to show us how they use the different AI technologies or platforms that they use, and we saw ways that they did that, and in my view, like one of the examples was the artist had drawn a picture of a person. She had also drawn a picture of a hat. And she wanted to combine the two, and she just asked the AI, I think it was Midjourney, but I could be wrong about that, to put the hat on the person. Those are two separate things. All that they did was move the hat on there. That's a visual prompt as opposed to a text prompt. That's something the Copyright Office did not consider and is not in their guidance. So I think the answer is absolutely yes. And even if you're talking about text prompts, I think it really does depend on the detail of the text prompts. And if you look at the Copyright Office's standard, which is, can you, if I remember correctly, was can you like expect the result? What result
right.
can you expect? Yeah. I'm not sure that's a good standard. Let me just put that out there.
Agreed.
But assuming that to be the standard, if the prompt is specific enough, I think the answer to that is yes. And therefore, the person should be the author in the eyes of the copyright law, and therefore have copyright protection for that image.
Thank you very much.
I have a quick but probably difficult question. Are we going to need bots to manage the bots and to monitor the bots? Because we're not good enough as individuals, as humans, to really realize what's being created here. Anyone on the panel?
Well, I'll answer sort of. There's a product out there by the University of Chicago they put out, maybe product may not be the right word, but called Glaze. I don't know who's heard of this, but it's basically put out to allow visual artists to trick the AI, because AI, it's not, their works aren't being licensed, so they're not trying to find out how to combat that. And they're using this product called Glaze to trick the AI to think it's something else, or it can't learn from it, if that's the right word. I'm not sure it is, in the right way. I think it's sort of problematic, right? It's basically teaching the AI that 2 + 2 is 6, which isn't great. But you can't blame the visual artist or University of Chicago or anyone for doing something like that, because until their creators' rights are respected, this is the corner that they're painted into. And so it doesn't really answer your question about AI monitoring AI, but AI battling AI. It's the same. It's sort of the flip side of that coin, I think.
Any other, there's a question in the back.
Thank you. Back in the day when we were doing satellite radio, we had to deal with a lot of similar issues as we were digitizing music. And I had friends and other people in the music industry that swore that I and everyone else that was working on that was going to ruin the life of the artists. Over the story arc, right, where we find ourselves now, DRM was created, so digital rights management, and it's like so much stronger than anything that we had back in the 90s when we were first starting to do this stuff. Are there things that we can pull from that experience as a muse as we go into this generative AI era where we're sort of dealing with similar types of issues around intellectual property of content?
I think there certainly will. I mentioned Glaze already. There's certainly some technological type solutions. I think what you may see is more collective licensing than we've seen in the past to make it easy for AI developers to license from visual artists, authors. There's already collective licensing in music, for instance, and in other areas. So I think you're certainly going to see changes here, both in terms of the way people do business, the way what licensing looks like, certain technologies and things. There's no doubt. I think we're just on the cusp of that, but I think we're going to start seeing more and more of that as we move forward here.
Yeah, I do think it's a little bit of a can you put the genie back in the bottle, though, because I think that people have become accustomed to, Sean Fanning actually was an undergrad here at Northeastern when he started Napster, and back then, that was 1999, 2000, there was a lot of commotion around music licensing, and then somehow the industry sort of figured out that people didn't want to deal with that, and now with a iTunes subscription, I'm shielded from from even knowing about that intellectual property. So I don't know if there's if now we're kind of coming back and saying, well, no, this stuff really is valuable, and we really do want to ascribe value to it. I think the other thing that is always a question is, do you then, if you're creating a tool or licensing data, is the output something that can be, if you had a movie-making application, I don't know what Adobe's movie-making application is, but then you pay for the tool and then you don't get a cut of the movie that gets produced. But are we, is that something that is being discussed either in the type of licensing that you're doing, Nimra, or that people are thinking of sort of these different models of how people get compensated?
I can speak a little bit about it on our side. Because we haven't traditionally licensed data for dollars. All of it is kind of built around these co-development or collaboration types of relationships. And there is a lot of the discussion is about what is the value back to our system. Is it the fact that our researchers get to be involved in the creation of these products? It's improving research opportunities, opportunities for us to be able to publish, opportunities for us to be able to create better solutions for patients. All that is part of is the consideration for the data going outside of the institution. It's not, and it can also mean often if that product is eventually commercialized, we then see some kind of upside either through royalties or participation in the company, things like that. So we have tried to look at all different forms of consideration back to the hospital. Not all of it is monetary. Some of it supports our research mission.
Gotcha.
Myron, I think we're out of time for now. But thank
All right,
you
well,
very
thank you.
much,
Yeah.
panel. It was a great panel. Thank you very much. Applause.
Thank you.